Yes.
May I seek your lordship indulgence in making a mention with respect to part two, item number 2. Yes, my lord, this matter is fixed for hearing today, but the leading counsel, Joseph Lelton Himarente, could not appear today due to some personal difficulties. So if this matter may come up next week.
We have to adjourn if he's not available. What's wrong with him?
Actually, my lord, yes, it's up to your lordship. But now, since the matter has been pending for quite some time, it's 2019 RFA, lordship. And number two, today's service fixed on their prayer month. From past.
But what happened to him?
Yes, my lord, he's having some personal difficulties with all the babies and all.
Oh, okay.
He's recently blessed with a baby boy. That's what, my lord.
Okay, we'll adjourn. Unless there's some real urgency in the matter. Yes, heard.
Actually, my lord,
Yes.
they now, if we keep pending this matter, my lord, as long as we keep it pending, they are now enjoying the land.
Enjoying what? The land.
land.
What are they doing over the land?
Actually, they are now illegal occupants of my land.
We'll see, isn't it? Anyway, I heard Miss Rosie Manlom Sangi, Learned Counsel for the respondent, who has prayed for adjournment of the matter since her senior, Mr. Joseph Lalchan Hima Rentle, Learned Counsel, is not able to appear due to some personal difficulties. Stop. Mr. Caesar Ramchana, Learned Counsel for the appellant, has expressed urgency in the matter. In view of the above, matter be listed in the next week. We'll not fix a date, we'll keep it open for the whole week. Okay, then I think whenever the both of you are available, you contact find out when your senior will be available, then during the whole week, any day you can this thing. Okay, and list the matter in the next week.
Obliged.
Oblige.
In view of the above, list the matter in the next week.
Lordship, I seek your indulgence in mentioning part 2, item number 9. Lordship, may the case be taken up on a fixed date at 24th October?
9.
Yes, my lord.
You are for the respondent.
Yes, my lord.
Who's for the, okay, yeah, so not this thing, okay. I will just make it on the prayer made by the learned councils for both the parties. List the matter on
24th October.
24/10/2020. What's 24th? It's not a Wednesday, is it? Or
It's on
a
Friday.
Monday. No, 24th is a Friday. Okay, 24th.
Obliged.
For motion, item number 1.
Yes.
May please, Lordship. My Lord, the present matter pertains to seeking an appropriate direction from this honorable court against the state respondents, specifically against the settlement officer of Land Revenue and Settlement Department, Champai District, to pass an appropriate settlement order wherein the concerned authority of the settlement office failed to pass any order in respect of a land dispute, my lord. Here there is a land dispute at Champai, my lord. I am the landowner and covered by permit number 20 of 1963, my lord. And if your lordship may kindly see the page number 19 of the summon letter issued by the settlement officer, Champai District. Here, the parties are directed to appear before the settlement office. But after discussing the matter, the concerned authority failed to pass any order. And if your lordship may kindly see page 21, and a simple note sheet was made, wherein at page 22, the English version is like this. There is a land dispute regarding this pass. They have been called to the settlement office and have been directed to approach the court. Therefore, the council passed permit number is stayed till until further notice.
So maybe it's
But-
beyond this thing of the settlement officer.
But my lord, the thing is that as per the relevant provision of the present Mizoram Land Revenue Act 2013, the land revenue dispute has to be entertained by the authority as per
Let's see.
the relevant provision of this act,
Yes,
specifically at section 89, my lord.
let's see. '89.
My lord, here,
Wait, section 89, Mizoram Representation. No. Mizoram Land Revenue Act.
the
Okay,
Mizoram
wait.
Revenue
Land Revenue Act,
Land
isn't
Revenue
it?
Act 2013, yes, my lord. Here, my lord,
Yes,
this particular act said
section
that
89. Let's see.
before that, section 87 also.
They're saying it's a revenue court. 89.
Here, before that, if we can come to 87, my lord.
87.
Yes. Appearance before and applications to revenue officers. All appearances before applications to an act to be done before any revenue officers under this act or any other law for the time being in force may be made or done by the parties themselves or by their authorized agents or by any legal practitioner.
This is procedure of revenue courts,
Yes,
isn't
my
it?
lord, yes.
So you're saying this is a revenue court, is it?
Yes, they have the power to entertain, and if we,
Where? So let's look at the power of the revenue court. Any question of law, of fact or law arising out of orders?
if we can come to section 76 also, my lord. Chapter 8. This
You
is
have to
the
get to
procedure of
complete-
revenue courts.
Huh. Yes.
And by relying on this relevant provision, the revenue court,
Read 76.
76, yes.
Huh.
A revenue officer, while exercising power under this act or any other law for the time being in force, will inquire into or to decide on any question of fact or law arising out of orders for determination between the government and any person or between parties to any proceedings shall be a revenue court.
So what was the application made by you?
The application was made by Mr. Ming Tanzama, who is a resident of Champai.
Where is it?
This is written at page number 9 of the summon copy, my lord,
Of the?
of the writ petition.
No, how did you approach the revenue court? Where's that first, this thing? You have to give it the background, no, just not the order. How did you approach this thing? Under what, so why was notice issued to you for appearance?
The notice was issued, this is the notice, my lord, here. Page 19 is the notice.
No, but how did you approach the revenue court? On what grounds have you approached?
This is this is approached by Mr. Ming Tanzama. This is the relative of my husband. Actually, the original land is in the name of my husband. But after the death of my husband,
So where's that this thing, letter in the name of your husband showing that you had approached the revenue court? You have to make an application before the revenue court.
my
Okay.
lord, here the thing is that initially I'm not approaching the revenue authority, revenue court. The other party
Then
are
they don't have
approaching.
to make any order if you did not approach.
They are approaching, and this court has also made the summon, my lord. Here, here they approach.
But
and-
on what grounds? No. Because I'm just saying that maybe what you have approached, what you have prayed for is beyond what the settlement officer can decide, and he has told you to approach the civil court.
My lord,
Because
if I,
no sections of law has been mentioned.
if I may read this page 20, that's a translated copy. Notice
So we want to see this complaint. See, page 20.
Yes.
With regards to the complaint filed
Filed by-
by Miss so-and-so and
Yes.
so-and-so on so-and-so, there appears to be land dispute. If it
Yes.
is land dispute concerning what title, then you have to see whether it's the revenue court is the competent authority, because here it appears that the settlement officer feels that he's not competent to look into the matter and has given you an advice to approach the civil court.
even,
So
my lord,
what's wrong?
even under
That's
such,
the order. That's the
even
order.
under such a situation, my lord, there has to be appropriate order.
So
issued
you
by
have you
concerned
gone on
authority.
appeal against this to the appellate court? If you say this is the revenue court,
My lord, after this, I prefer an appeal to the concerned authority, and that is at page 23, my lord.
23. So
Yes.
you're unhappy with this? What is the order of the concerned authority?
This is the concerned appellate authority had made a direction to take appropriate step by passing an appropriate order.
Oh.
That is at page, my
Then
lord,
you approach this thing against, when was this dated? You're unhappy with this?
my lord, after the appellate authority made a direction to the settlement officer to pass an appropriate order, I had again made an application to the concerned authority of the settlement officer again, which is that.
Or
which
you go to the appellate authority if it's not obeying? Where's the order of the appellate authority?
the
If
order
this-
of appellate
you say
authority
this
is
is
that-
the revenue court,
Page 34, my lord. The translated version is at page 35.
Yes, you exhaust your remedies first, huh? What
Yes.
does it say?
If I may go from
Yes.
the second para, my lord. Your first appeal application regarding Srimati Nukungi Council Pass Permit Number 20 of 1963, location Champai have been forwarded to the Settlement Officer, Champai District. According to the Settlement Officer, information and copy of hearing conducted regarding the said land pass have not been recorded in writing, and Srimati Nukungi have been verbally informed of the same. Appropriate settlement order has not been issued with respect to the said land pass according to Settlement Officer, Champai District. An advisory was made to the settlement officer to settle the matter regarding the said land pass as soon as possible. This is the
So,
order. And after
you're
this,
appealing against this order or what?
I am,
Appellate authority has passed an order.
yes, pass an order, and in the light of the order passed by the appellate authority, my lord, another application was made again, which is at page 36. The translated version is at page 38 on 18/7/2025. But still, no step has been taken so far.
So you go back to this thing, appellate authority, and say no steps have been taken.
Yes,
Because you
madam.
are happy with the order of the appellate authority, isn't it?
I am happy, but the direction is not complete, my lord, complete and final. It advisory was made to the settlement officer to settle the matter. Meaning
So
that
you are unhappy with the appellate authority's order, is it?
I'm happy, but the
Then?
appellate authority,
Then you go report back to the appellate authority. So what is the final authority based on the order of the appellate authority?
the
Because I'm not
Advisory
very
was
sure
made.
whether you have a case or not. You have to first bring the material on record showing what is the nature of the complaint made by the complainant. It's very incomplete. Okay, before the settlement officer, whether it is in the nature which can be decided by the revenue court or not. We have to see that first. Okay. Then, because it appears to me the settlement officer feels that this is beyond his jurisdiction and has advised you to approach the civil court.
Those
isn't it?
observations are not made, my lord. There was no
No,
specific.
he has told you to approach this thing, civil court, to Boyd here, because it is a settlement.
As per the, if, my lord, in that regard, if I may go to section 96 of the Land Revenue Act, section 96, subsection 1.
96 is concerning what?
This is concerning the
Revenue court.
authority of the revenue court, if I may read, my lord.
So is the application made by you within the exclusive jurisdiction of the revenue court? We have to see to
Yes,
that.
that is the
Which is the matter here? Which one?
subsection 1 and subsection 2, my lord. If I may read. Save as otherwise provided in this act or any other law for the time being in force, the revenue court shall have jurisdiction to determine, decide, and dispose of any matter which it is by or under this act empowered to determine, decide, or dispose of, and no civil court shall exercise jurisdiction as to any of such matters. Subsection 2. Subject to the exception herein after specified, no civil court shall exercise jurisdiction as to any of the following matters.
Under which matter? It comes under which one? Revenue
This
court.
is
Which one?
this is the
Amount to the amount or incident of assessment. This is not the matter here.
this is
isn't
not
it?
the matter.
Then to
This is
the mode of assessment or levy of collection. Anything? Collection of taxes? Nothing.
this is not the issue here,
Then
my
the
lord.
validity of effect of the notification. Which is the notification issued?
That is, the notification is only for summons to appear, my lord.
So that's why, what is your application made before the court? Then which one?
The
Under
application
which?
pertains
So under
to-
which, two, which one? 2B, which one are you? Have you approached the revenue court?
I'm approaching the, actually, initially, as I had already submitted, my lord, the initial application was filed by another person claiming the land, my lord, claiming ownership of the land without having any.
Then if it's
genuine
ownership
land
and title, it is the civil court, not the revenue court. That's why we want to see, find out, get it from RTI Act. Because it appears that the settlement officer says that this is a matter which has to be settled by the civil court. So you have to show this court that this is a matter which is under the exclusive jurisdiction of the revenue court, okay? And the revenue court has to settle the matter. Then you have to show me here, section 96, these are the exclusively tried to be tried by the revenue court. So which is the, under which this thing provision have you approached the
This is
revenue
with
court?
respect to the sub number F, my lord.
F,
F is distribution of land and allotment of land.
distribution of land or allotment of
allotment of
revenue or
land.
partition or under this act. Then you have to show me which is the distribution of land. There's a vacant land, it has to be distributed by the revenue court, isn't it?
My lord, here I am the genuine landowner. Vide permit, I have already enclosed my land pass, my lord.
So it's this thing, dispute over title, is it?
Yes, my lord,
Then
exactly.
it has to be the civil court. If it's a dispute over titleship of a land, you're fighting over the title of the land.
But my lord, in
So
my
find out the first application. Your application, how did you approach the revenue court? On what basis? Find that out. Do your homework. Tell you this thing.
Initially,
because
my
the revenue court, after considering your application, finds that it doesn't have the jurisdiction to settle the matter and advise to go to the civil court. So we have to see what is the nature of the dispute, what is the application made. Nothing is clear here. It's only summons issued. Then after that, the revenue court says that you have to approach the civil court, isn't it? So what is the nature of the dispute? What is it in your application made before? How did you approach the revenue court? Find that out. Then we'll see whether it's a matter regarding ownership, title and all that. And then we'll see whether it's a civil court or the revenue court. Then if the revenue court is running away from its responsibility, then it's a different matter. But we have to see why has the settlement officer said that this is a matter to be settled between the civil court. So you must have approached the revenue court by making some application, because here it says, I've seen the, considering the application made. Let's see the nature of the application.
Malo.
Isn't it? This is the
Malo.
matter.
Malo.
So when will you be ready? Then, because the settlement officer cannot run away from his responsibility. I'm getting your point. But why has he said that this is a matter to be settled by the civil court? You will have to look into the application,
Malo.
the nature, isn't
Malo.
it?
Malo.
Yes. I heard Mr. Eflal Engliana, Learned Counsel for the petitioner, on the submission made by the Learned Counsel for the petitioner, list the matter. How much after? 1 week?
My lord, it's Champhai district and
Okay.
I would need more than 1 week, my lord. If,
3 weeks
my lord.
after 3 weeks.
Obliged.
Yes.
For admission, item number 2.
Lordship, here I had to file rejoinder. But the thing is that, my lord, there is, of course, there is pending civil litigation. Then we file rejection of that civil eviction suit actually before junior division, because the property is at the heart of the city. So it was around 8 crore, 7 crores.
Which city?
In that Zemabok,
Okay.
no, in Bongkon Brigade. In the,
No,
along
so
the
all
road.
you have to do is file your rejoinder. We'll
My lord,
fix it
the thing is
shortly.
that I'll
Last
tell you, my lord,
chance.
I'll submit
Or you
that.
don't have to
My lords, I
file.
have
No, my lord, I'll submit that in respect. We file it, they could not file written objection. Then only yesterday they filed objection.
Oh, you got your.
Yeah,
this
that's why I
thing.
want to keep on the record. Yesterday only they filed
My
objection.
lords, may I?
But in the
And on
previous,
4th November, on
no,
4th November, it was fixed.
Okay, who has prayed for further time to file their rejoinder to the affidavit in opposition. When did you file your affidavit in opposition?
My lords,
This is 16/9/2025.
it has been some time, my lords, sometime early this year, in fact, my lords. If your lordship sees the past orders, they've been seeking time since June, my
Because
lords.
of
One second,
their
one second.
failure to file written objection in that rejoinder,
My
that
lords, he's mixing
rejections
up-
were plain.
my lord-
Yesterday only they filed, your
Wait,
lordship.
wait. What did you file yesterday?
No, my lords. What he's saying is that in the proceedings, parallel proceedings before the learned civil court,
Oh, civil court.
yes, my lords, there.
In this case,
In
you
this
have to
case, my
file.
lords, he wants to bring those on record. Our only objection
Because
today
they
is-
make
one
submission.
second. Our only objection today is, my lords, that there are parallel proceedings today, and they're taking advantage of that fact.
No, they are taking advantage
How
of
can-
that.
No, this thing we'll give a final chance.
My lord, yes, my lord,
File a
yesterday they
counter
filed.
affidavit.
Yes, we have.
Yesterday you filed, we are concerned with the case which is pending here in this court, okay? Because they have filed a counter, you're going to reply to the
Yes,
counter.
yes. Yesterday they filed, we have the copy now.
You have to reply to this thing, to the
Yes,
counter affidavit
yes.
filed by them.
Yes.
Keep that in mind. Okay. Yes.
Next date
Now,
is,
heard Mr. J.C. Lalnunsanga, Learned Counsel for the petitioner, who has prayed for further time to file his counter affidavit by submitting that there is a parallel case pending before the civil court wherein the petitioners had filed their written objection. What is the
My
civil,
lord, respondent.
what is the civil court registered as?
my lord, will come. My lord, eviction suit number 16, 2023.
Eviction suit number 16/2023, wherein the present respondents had filed a written objection in the said eviction suit. Full stop. The learned counsel submitted that he would like to reflect some points regarding the written objection filed in the eviction suit, and therefore further time may be given to file his rejoinder affidavit in the instant writ petition. In view of the
Last
above,
opportunity.
in view of the above, this court find it fit to give further time to the petitioners to file their rejoinder affidavit, failing which this court shall pass appropriate orders. Lest the matter
Second week of November, my lord.
My lords, that would be stretching it. The
My lord, that-
proceedings,
no, that-
as my learned friend said,
Hearing,
it's
hearing
happening
in
on
that
4th
respect is on 4th November.
And
Then
there they will
that,
take-
that case
Okay,
will be
file your rejoinder, let's see, in view of the
4th
above
November.
list on 4th.
second,
My
no,
lords,
my lord,
before
2nd of
4th,
November, any day.
date before 4th, I would not object, my lords. They're trying to take advantage
No,
of.
that's
No,
it.
file a rejoinder in the next date. Whatever happens, let it happen. Counter has been filed, you have to find a rejoinder. Let's leave it at that.
Then
Okay.
this one-
This court doesn't know what is going on in the other
Yes.
court, but concentrate on the writ
Yes,
petition.
second week of November, lordship.
No, you file a rejoinder affidavit. You're waiting for the outcome of that,
Yes.
whatever. Concentrate on the counter
Yes.
affidavit that is filed here, isn't it?
Yes, lordship.
In view of the above, what is the case about anyways?
My
Property?
lords,
huh?
here in this writ, they're trying to, my lords, declare their own title, which they've already lost in the first round in the declaration.
No, not at all, my lord.
Anyway, in view of the above, a list,
Second
Last
week.
week of October, my lords. That would be most fair, before the date of the proceedings.
see, it's only filing the counter affidavit.
Yes.
File a counter, then maybe if pleadings are complete, next step can be considered.
27th.
In view of the above, list on, we'll make it the last week of October, a list on 31st, 10, 20, 25.
Great. Obliged.
This court must not be guided by the district court, what is going on.
But they raised that issue, that's why we come up.
So you come up there, you've got a copy of the written objection now, isn't it? Yes.
Item number 3.
Lordship, we have found the address of the proprietor in this of respondent number 1. Since it is a sole proprietorship, Lordship, we can take fresh steps upon the proprietor.
Okay. Heard Ms. H. Malswamy, learned counsel for the petitioner, who submits that since they have obtained the correct address of the respondent number,
Number 1.
Number
Number
one.
1, the proprietor of the respondent number 1, that is the Balaji Developers.
correct address of respondent number 1, no, obtain the correct address of the proprietor of respondent number 1.
Yes.
So you have not made the proprietor the party
Proprietor,
or what?
it's represented, Lordship, respondent number 1 is the Balaji Developers, represented by its proprietor. So we haven't written the address of the,
It's
yes,
basically
it's
respondent number 1,
yes.
isn't it? Correct address of respondent number 1. She may be allowed to take steps for issuance of notice upon fresh steps, okay, for issuance of notice upon respondent number 1. What, through registered or
Register
dusty?
post ID, since it's
Accordingly,
in Delhi.
the learned counsel for the petitioner is to issue notice to respondent number 1 through registered post with AD within 3 working days, returnable by 3 weeks. Full stop.
Lordship.
Then,
Lordship, if I may, if we can
as well
take
as through
back,
dusty
yes.
motor. Okay, as
If we
well
can
as-
take back the unserved copy, Lordship, we have taken,
So you wanted through dusty also? No.
no,
Okay,
Lordship, it's
to
impossible,
returnable
Lordship.
within 3 weeks, okay. The learned counsels may be allowed to, the learned counsel for the petitioner may be allowed to, what?
Take back the unserved copy, Lordship.
Is may be
Of the
allowed
petition.
to take back the unserved notice issued to the respondent number 1 previously. Good stuff. Then the presence of Ms. Vani Isyami, learned government advocate for respondents number 3 and Mr.
Arla Hunsiyama,
Alvin
number 2.
Munsiama for respondent number 2 as noted. Yes. Just after 3 weeks.
Item number 4.
Lordship, this is application for quashing of criminal complaint 1/2024. That the very small fact is that issue is that regarding loan payment, inability to loan payment. So my lord, I have some only 2-3 grounds. and that my first is that it is civil dispute.
So who is representing the respondent? You're representing?
So today is fixed for final hearing. Attempt were made.
No, today it's
For
not
a
been, so you were trying to come to some settlement,
No, my lord,
isn't
we
it?
tried two, 3 times, and even the case.
Has the
prolonged
matter
delay.
been this thing,
no.
sent for mediation? Send it for mediation. We make an attempt there because outside, when the parties try just by themselves, it will be difficult, isn't it? So since it appears that you had tried to come to some settlement, we list it for mediation, get advice from your councils.
But actually, my client, I have spoken to them also.
Concerning what,
And
mediation?
Yes, even Adalat also, even 2, 3 times also. So they want to dispose of.
Okay, we'll fix some other date then. Heard Mr. J.C. Lildan Sanga, learned counsel for the petitioner, along with is your name here in the cost list? Mr. K. Rowland, learned counsel for the respondents. It is seen that the court had suggested before, isn't it?
Yes.
It is seen that though the court had suggested that the parties may consider referring the matter to mediation. However, the learned counsel for the petitioner submits that the petitioner is not willing to have the matter placed before mediation. In view of the above, anything you want to take into steps?
No.
Nothing.
Nothing.
No, yes.
But just,
In view of the above,
but
matter
to,
may be listed. When you want it, on 21st? Maybe on the 21st, matter may be listed on 21, 10, 20, 25, wherein an attempt may be made to dispose of the matter. Yes.
much obliged.
Item number 5.
Yes. Lordship, this application is regarding reduction of the Zimanama bond to be executed by the petitioner for releasing his vehicle. So, my lord, the brief facts of the case is that my vehicle was seized on 27/09/2023. And before the Nane trial court, we have applied 2 applications for releasing the said vehicle, but it was failed. And we came before this honorable court, and this honorable court filed the order dated 24/07/2025. That is at page 27, annexure 9. Allowed the vehicle to release. So if I may take a lordship to the relevant portion at page 35, that is the last page of the order.
Page 35.
Yes, that is the relevant portion of this honorable court order. Yes. My lord, if I may read para 13. Yes. As such, the Learned Judge Special Court Indian PS Aizawl is directed to release the seized vehicle so and so, red color bearing registration number so and so, chassis number so and so, NG number so and so. Vehicle documents and its ignition key to the above named petitioner on his proper identification and on verification of all the relevant documents relating to the seized vehicle, the said vehicle in original and after taking photograph of the said vehicle and on furnishing the Zimanama bond equivalent to the market value of the seized vehicle. So, what the reason we came before this honorable court is that consequent to this order, the Lanet Trial Court made the order, that is at page number 36. If I may take your lordship to page 37, the last para, that is the relevant portion. The applicant shall execute Zimanama bond amounting to rupees 15 lakhs only, which is estimated as the market value of the state vehicle.
Yes, what is
So
the
we
market
could not-
value?
Yes, we could not satisfy this amount, so we came before this honorable court for modification of that Zimanama bond. It is too high for us because this vehicle was taken on loan. We still need to pay a huge amount for the loan. So it is too much for us.
Actually, you should go to the same judge, isn't it? You wait for him, he'll be coming sometime soon.
My lord, if your lordship may dispose of, because
The same bench who passed this order will most probably coming. Will be sitting again. So market value is agreed, it's 15 lakhs, is it?
it is estimated by the trial court.
So maybe a re-estimate. What's a vehicle? A truck?
Yes, it's a truck.
Who will do the estimation then?
The land trial court.
No, here, some competent authority, MVI or something will have to do this thing, estimation of the price of the vehicle. How old is it? When was it purchased? Something, some basis, the estimate made by the trial court, maybe that is not appropriate. Instead of changing the order already passed by a bench of this court, otherwise it should go back to the same bench. Which is estimated, how was this amount estimated? 15 lakhs?
Yes, Your Lordship. I believe that the estimate was made by the learned trial court.
By looking at the vehicle or what? How did it arrive at this?
Yes,
We
Your
have-
Lordship.
we
Regarding
have-
by looking at the registration certificate.
Okay, what is this thing? Registration certificate, when was it purchased, the vehicle?
The registration certificate is not annexed herein,
It is not annexed here in this
Then-
petition.
because it is only for modification of the Zimanama bond.
But here it says the estimate value of the vehicle. So we'll have to, this thing, see, it is, if it was before the same bench, it was a different matter, isn't it?
Yes, Your Lordship, if I may. In my humble opinion, it will be more appropriate to approach the same
Yes.
court
So,
and praise
the
for-
same court, through VC also you can fix. It's not that they have to be physically present. There are many cases now where through VC, they'll fix a date and then it's his order. I'm doing the same thing with Kohima bench also because I don't sit in Kohima recently. So a few orders which needs to be reviewed or reconsidered, we do it through VC, it's nothing difficult. Isn't it?
But my lord, it's only for the purpose of that reduction, so.
Oh.
Yes.
But how can we reduce, so you want it to be the amount. We can ask the court to, in compliance with this court's order, to see how the amount has been estimated to be 15 lakhs.
Yes.
If you want, we can do that.
Yes, my lord, what the trial court had directed us is to execute that bond. See, the problem is that
Yeah,
we
so
don't have any
execute
money
that bond.
to deposit before the land.
So did you place that same matter before the court would pass the order? Because here, where's the order of this court?
It is at page 27.
On furnishing the
Yes.
Zimanana bond.
Yes.
So you have to furnish
Yes.
that bond. So you're asking me to change the order which was made by a bench of this court. So I'm saying then the matter should be placed before the same bench who had passed this order, because the bench has written a long judgment. It has considered the pros and cons as to how the vehicle was seized and what is the seized amount, and it can come to a decision. This bench was aware that it will be a huge amount.
My lord, if I may suggest something, that see, that 15 lakhs may be the market value, but what our problem is to deposit before the trial court. So maybe it may be appropriate to fix that as a market value, but what our problem is to deposit before the learned trial court.
So when it says on furnishing
Yes.
Zimanama bond, does it mean that you have to furnish it in the court or no? How do you interpret this?
My lord, on furnishing, as per my interpretation, it may be not to be executed before, to deposit before the learned trial court.
Yes, what do you say?
Yes, Your Lordship. In my humble opinion, I believe that they have to submit the bond before releasing by Zimanama. And Your Lordship, in my humble opinion, if the learned petitioner applies for modification to this sentence, if he want to deposit later on, so he can ask.
So get something to show that this on furnishing the Zimanama bond. What do you mean by on furnishing?
My lord, as a custom practice we have met before the learned trial court also. See, if bail was allowed and to on furnishing some bond, we did not.
No, we don't use the word furnishing. That's the whole thing. No, we just say with a bond of so and so. Okay, we never use the term furnishing a bond.
Exactly. Your Lordship.
So when we say furnishing a bond, is the money required to be deposited or not? You come up with some authority or something, then
Okay.
trying to convince. Even I'm not sure what is the give me some this thing where the term furnishing a bond has been used, but the said amount was not deposited. I don't know how to interpret this, frankly, right now. How do we interpret this term? So you convince this court, we'll fix the next date.
Okay, ma'am.
Show me at least some bail, because usually when we grant bail, we just mention the bond with a bond of so much. Okay, we never say on furnishing a bond. So when you say furnishing a bond, what did it mean? Or you show me some examples where the terms on furnishing a bond has been used, but it is just signing a bond and the actual execution or the actual deposit is not paid. Because it appears to me even the learned trial court had interpreted this furnishing by saying that the amount has to be executed. So you have to convince this court that furnishing does not mean the actual execution of the bond amount. Okay, that you come up with, so that at least this court is convinced that the trial court had wrongly interpreted this furnishing when it should not be executing but on furnishing. That
Your Lordship,
language.
if I may,
Uh.
in my past experience, in a bond, wherever in a bail bond or whatever, it is always written with a bond of.
Oh, with the
so
bond.
and
That's
so.
what. So he's saying.
in this case,
so
it
the
is
counsel,
precisely saying
his
that to
counsel is
furnish.
saying that furnishing does not mean executing. So do your homework. Show if you have some material to base your argument. We'll give you a chance. That's what I'm saying, isn't it? Because he has to convince the court, but he is just come with his simple interpretation. So have something to base. If you have enough material with your submission, then we can consider, isn't it? I heard Mr. J.H. Ramne Moya. Is it Learned Counsel for the petitioner, along with Ms. Vane Isyami, learned additional PP for the state respondents. On the prayer made by the Learned Counsel for the petitioner, matter is adjourned. List, yes, when do you want it? In the next week or what?
Next week.
List in the next week.
Item number 6.
May I please, Your Lordship. My Lord, before we go into the case, I would like to submit to the court that I have obtained the airship certificate number 711 of 2012 through a certified true copy on 27/8/2025. This airship certificate is the main part of my appeal and also in this application. And the reason for our delay is, as I've said, we could not obtain this airship certificate, my lord. If I take it,
Wait, when was the judgment? What is it?
yes, before going into details, may I take your lordship, I'll take a brief text as state the brief text. So I filed civil suit number 38 of 2018 before the trial court for declaring that I have the right and title over LSC number 27 of 1973 and for evicting the defendant number 1. And the defendant number 1's mother had obtained a loan from me, private loan from me, amounting to 17,20,000. And instead of mortgaging their landed property, the defendant number 1, I and defendant number 1 had executed sale deed dated 17/8/2017 and 1/3/2018. And based on that sale deed, on the strength of the sale deed, LSC number 27 of 1973 was mutated in my name. And therefore, I filed civil suit number 38 of 2018 for the lower court. And ultimately, the judgment was pronounced in favor of the respondent here in matter, because the defendant number 1 was declared as unsound mind. But in the trial court, I have pleaded that there was a previous heirship certificate issued in the name of the defendant number 1. So, issuing heirship certificate to an unsound mind is not proper. And that is the brief facts, my lord.
But if he's of unsound mind, he must be having some legal
Yes,
guardian.
yes. Now, later on, belatedly, they have a guardianship certificate.
Oh, so
But the heirship certificate was,
he's also a human being. He's a person.
yes,
It's
yes.
in his name.
But the heirship certificate was later on, as we have found, issued in his name, not through a guardian, applied in his name, not through a guardian. So how can an unsound mind apply for heirship certificate?
Because then you have to look into the level of his unsoundness. They can still do a lot of things. He can be aware that he has the right to inherit against his from the properties of his mother or father. That much he can have. He can have the knowledge. You
Yes.
cannot treat him just because he's unsound mind. He
But
doesn't
the-
have the
but,
sense
my
that he
lord,
can. You cannot just write him off. He's also a human. He has the rights, all the fundamental rights.
Yes.
So he has a right to inherit. Okay. So we have to look at the application.
yes,
Who
yes,
made the
definitely.
application on his behalf? Anyone can make, even if it's not the guardian, if he knows that he has a right.
Definitely, madam. But my main question is that if the defendant number 1 is allowed to submit the airship certificate number 711 of 2012 in his own name by himself, then
You must
Why-
be of sound mind.
yes, why is my sale deed declared null and void, executed between me and the defendant number 1?
So now your appeal is against what? Which order? Why is it delayed?
Yes, order dated 4/10/2024, my lord. And the main
By how
reason-
many days?
61 days, my lord. The main reason for our delay is that the defendant number 1 had withheld the copy of this airship certificate even before the trial court.
Airship certificate is dated?
10 September 2012, my lord.
But this thing is not 2012. Yours
This
is
is
the
2018.
order dated which one?
2010, my lord.
How many days?
4/10/2024. 61 days.
410, 410/2024. So we are going to concentrate only on 410/2024 right now, not on
Yes.
the merits of the case, isn't
yes,
it? So when did you get to know about 410? Not the airship, leave the airship. 410/2024. Let's see.
The period of appeal expired on
410/2024.
Yes, my lord. Period of appeal expired during holiday. That is 2/1/2025, my lord.
Let's see, where's the holiday list? The impugned order is 410/2024. Okay, yes. Then the holiday, there was a holiday during that period. When was the holidays? What holiday?
Winter vacation, my lord. During the winter vacation, it has expired, the period of application.
When will it expire?
On 2/1/2025. And as I have stated in my petition, the petitioner herein was of old age and is having certain ailments and could not approach the honorable court for immediate filing right after the start of the court. And also, as I've stated in my petition, as we have applied for the airship certificate through RTI, since we could not get any information from the defendant or from the lower court or during the pendency of court of the trial. So our first RTI was rejected.
But when did you get the certified true copy of the impugned order, 410/2024?
Yes.
When did you get this certified copy?
Certified copy was
410/20. Let's forget about the airship. That will come when the case has been considered. First, we have to look into the
on
limitation.
10/12, my lord.
410/2024 is the, and then you got the certified true copy on
10/12, my lord.
10/12/2024.
At the eve of the holiday.
Okay. Before the holidays. That's okay.
And my
Then-
lord, what I've stated here is that since at para 4.1,
Yes, para 4.1.
para 4, sub number 1, it may be submitted before your lordship that an RTI was submitted for obtaining information with regard to mutation of LSC number 27 of 1973 and the connected airship certificate. And the same was rejected on White memo number so and so dated 16 January 2025. And appeal was filed in connection with the same, which is pending for the appellate authority. And the aforementioned airship certificate forms the main part of the appeal, and necessary documents needs to be enclosed in the connecting RFA. And in the next point, I've stated that
So
the
you're saying that the delay, one of the delay is because of procurement of the documents
Yes.
required for filing the appeal?
Yes, my lord.
Okay,
And
Then?
it was rejected on 16 January, my lord. And after that, we have filed an appeal before the appellate authority, and which was on 31st January, an appeal was received. And my lord, after that, another rejection was issued, and this is all. This appeal was also rejected after the filing of this instant appeal, my lord. This instant case.
No, then you filed an appeal before the court of what? Additional district and district judge or what?
No, my lord. The
Which court?
RTI Appellate Authority, my lord.
Who is the earlier appellate authority? You
Department,
filed an appeal before which appellate authority?
I filed an appeal for rejection of my RTI before the Departmental Appellate Authority for first appeal.
Okay, RTI.
Yes,
huh.
madam.
Anyway,
That's
so
what I mean.
whatever, RTI, then what
And
happened?
then
huh?
only on 27th August, we are able to obtain the instant airship
So the
certificate.
time taken to procure the documents.
Yes.
Huh.
So without due to paucity of time and due to the limitation, we have filed the instant appeal without even obtaining the airship certificate. That is what I meant to say, madam. So there is no deliberate delay or the 61
Okay, wait,
delays.
so 410 is the judgment. When did you
Yes.
file this thing? RFA
4G.
403 2025.
Yes, madam.
Isn't it? Huh. So you're saying delay is 60 days,
61 days, madam.
61 days. So the delay of 61 days is caused, you got the certified true copy on?
On August of this year, madam.
Certified true copy of what, the judgment?
No,
Then just concentrate on that. Don't confuse
judgment was
this
on-
court with the other facts of the case. I'm not
Yes.
bothered with that.
Yes.
Okay, that we will consider only afterwards.
on 10/12, madam. Certified true copy of,
10/12.
yes.
So after 10/12, what steps did you take?
After 10/12, we applied for necessary documents.
Okay,
through RTI,
documents, which you
yes.
were not getting.
Yes,
Documents for filing the appeal.
Yes, madam.
Okay. Show us the application you made for filing the documents.
at Annex 1, madam.
An extra one. Here, you're saying that to file the appeal, you feel that you require the airship
Yes,
certificate.
yes, my lord.
Okay, so you took step on, application was made on, when is the date?
Application was received by the SPIO on 17/12/24
Okay, 17/12,
and rejected on 16/1.
Okay. So since you could not get this, what you required to file the appeal, after 16/1, what did you do?
I filed an appeal, departmental appeal, to the
Okay.
Departmental Appellate Authority, my lord.
Okay, then appeal RTI, Okay, so these were the steps you had taken, but since you were not getting the appropriate response, you filed the RFA on 4/03/2025.
Yes, my lord.
Okay. Got your point.
Yes.
So any authorities to rely on?
Yes,
Nothing?
my lord. 1998 7 SCC 123 and and 2005 G SCC 752.
So 1998 7 SCC, this is, you're relying on which para?
And Balakrishnan versus M.
Oh, okay.
Krishnan Murthy, at para 12 and 13, madam.
that the case should not be should be given a chance, isn't it?
Yes, my lord. And State of Nagaland versus Lipokau and others. Para 12.
State of Nagaland, I think it's concerning the government.
Yes, but the
State, steps to be taken by the state, isn't it, huh?
the
Which
expression
para?
para 12 and 14, my lord. That is, the liberal approach should be taken in.
Both liberal
Yes,
approach
yes.
should be taken, so that, yes. But this thing, state of Nagaland, this APOC, it's concerning the state
Yes,
government. Yes, okay.
Lordship, appearing on behalf of the respondent number 1, and as my learned friend has pointed out in his application, he has pointed out three different reasons why this delay should be allowed. But as this point goes on, I have another points where the delay should not be condoned. Firstly, it is regarding to the RTI application. RTI application was filed on the 17th of 12th, 2024. And may I please take your honor to, your lordship, to the application made by sorry, my counter affidavit.
In your counter affidavit,
Yes,
you are respondent number
number
1.
1. Page number 14. In Annex 1, page number 14, para number 2. May I, Your Lordship?
Yes.
That the defendant number 1 is the son of the late Sri Vanal Vena and late Srimati Zauram Liani. The defendant number 1 inherited the landed property covered under LSC number so-and-so from his late father by obtaining heirship certificate before the competent court. And he is the one who is occupying and residing at the aforesaid locality at Mission Veng, Aizawl, Mizoram. Here, my lord, this is the plain copy of the applicant in the lower court. And here they have already have a knowledge regarding the heirship certificate, which they have applied on the 17/12 of 2024. So knowingly that the heirship has been issued on behalf of the respondent number 1, yet the applicant had filed an RTI. So this is just the delay. This is just another reason for the applicant to have the sufficient reason for condonation of the delay. Point 1. And second point is regarding the judgment and order, my lord. It was passed on 4/10 of 2024. And the applicant has not pointed out when was the order received in his application. And as for reason, as a matter of fact, he has not, it has been a matter of like 74 days since the judgment and order was passed when the application was filed. So this could not be considered, my lord, as a reason for delay.
Okay, anything else?
And third point, the applicant also mentioned regarding the illness and the sickness of the applicant. And today, the applicant has not produced any material facts or any documents to show that the applicant was sick or of ill health. So as a result to all this, the applicant had failed to provide sufficient reasons, my lord, as to why this matter could not be taken up in that stipulated period of time. Therefore, this appeal may be dismissed if your lordship allows.
Application, isn't it? Yes.
And I have cited a case, citations, my lord.
Para?
Para 1, page 7. It is, however,
Para 1.
Para 1, page number 7. I have highlighted, my lord.
Oh, okay, yes.
It is, however, necessary to emphasize that even after sufficient cause has been shown, a party is not entitled to the condonation of delay in question as a matter of right. The proof of a sufficient cause is a condition precedent for the exercise of the discretionary jurisdiction vested in the court by Section 5. If sufficient cause is not proved, nothing further has to be done. The application for condoning delay has to be dismissed on that ground alone. Here, my lord, it is apparent.
Okay.
And I have again
One more.
cited another one, yes.
Yes.
With regard to Tirungan Nagalingam versus Lingeshwaran and another. Yes, my lord, page 17, para. Page 17.
You have highlighted the portion?
Yes, my lord.
Para what?
Para 31 and 32. It is a well-settled law that while considering the plea for continuation of delay, the first and foremost duty of the court is to first ascertain the bona fides of the explanation offered by the party seeking condonation rather than starting with the merits of the main matter. Only when sufficient cause or reasons given for the delay by the litigant and the oppositions of the other side is equally
Okay,
balanced.
now in your cited case, how many days is required to be condoned?
It's supposed to be 90.
Where? In which case? The one you're reading?
No,
The
to
cited
be
case?
condoned is 6. This one.
No, it is 1,116
Yes.
days. Okay, so let's not compare. It's very less here. Okay, then in the other one,
The other one, page number 7, para 26. Page number 7. I have highlighted.
yes,
Yes.
para.
Para 6 and 7. Yes. Point 6 and 7. Merely some persons obtain relief in similar matter. It does not mean that others are also entitled to the same benefit.
Okay, so is there a similar matter which we have allowed here?
Yes, it is
Where?
regarding to the delay anyway, my lord.
No, but here, what you're reading, some
Yes.
similar matter, he must have cited some similar matter. Is it? No. Anyways,
Okay. Shall I proceed, my lord?
yes, please, have you finished? Not yet.
Not yet. Merely some persons obtain relief in similar matters. It does not mean that the others are also entitled to the same benefit. If the court is not satisfied with the cause shown for the delay in filing the appeal, merits of the case are not required to be considered in condoning the delay.
Okay. Is that it?
Yes.
Okay, I've heard, I'll pass the order later, but condonation is allowed. Okay, 61 days allowed, disposed of. I'll pass the order later.
Deeply obliged, ma'am.
Yes. With reasons thereof, I'll pass the order. We'll hear the case on merits. Let's see whether he has a case or not.
Item 7.
Yes.
May I please, Lordship? My Lord,
Oh, this is 1,380.
Yes, ma'am.
That's a huge amount.
I'm coming to that point. This is an application for condonation of delay of 1,387 days in filing the connected appeal, my Lord. I would like to be very short in my making submission, my Lord. The impugned order was passed on 22 March 2021. 22/3/2021, my Lord. Without making a party to the present appellant, I am not aware of the heirship certificate issued by the court. No notice was given to us. In fact, my Lord, since the lower court got TC trial court TCR has not been called for, I have a copy of the lower court records so as to peruse for all of us. I'm giving a copy to my learned friend. This is a certificate copy of the lower court record. On 22/3/2021, this is an order passed by the senior civil judge. Seen and received heirship certificate number so-and-so, an application for issuance of heirship certificate under Mizo Marriage so-and-so, in respect of so-and-so, located at Vile of Kon, Aizawl, Mizoram. The application is submitted by R. Lalua Sangi, daughter of so-and-so, as applicant. The application has been duly verified and accompanied by court fees of ₹14 and affidavit annexures and vakalanama so-and-so in favor of so-and-so. Be it admitted and registered as heirship certificate application number 476 of 2021. Fixed, my Lord, 22/3/2021. This order, this application was put up on 22/3 and again fixed on 22/3. That means on the same day.
Oh, okay.
My Lord, then it seems from the records on the second page, one witness, Lalding Liani, who is a sibling of the respondent, was apparently produced, I should say, and evidence of the said witness was recorded. Vena kota heirship certificate lodil to Arla Luasangi hi kaunaw nunia, kanunaw hi panga kania kaunaw pa tepanile kaunaw nu pakhathi anboral toa tuna kapa zatsi ngaming LSC located at Vairakon, Aizawl Vena kaunaw nu Arla Luasangi in kota heirship certificate ron dil hi kashiat puin rem kati pui boka he LSC hi tu machu boy tu an loti Vena hian kot ma karon soye Vena hian he kot ma hian thudik tak ka soye. Signature was there, my Lord. Lalding Liani. Apparently,
But who now you're the appellant? Who
I am
are
the
you?
appellant.
Who are you? Are you a
Zonun
related?
Moi.
are
Zonun
you-
Moi is the father of Zonun Moi is the sibling of respondent, my Lord. And I have been occupying the disputed land. And my Lord, what
No, you are the granddaughter of the deceased, or what?
Yes,
How
my
are
Lord.
you
Granddaughter.
related?
Granddaughter of the deceased.
Okay, and the
LSC holder, my Lord.
Okay,
And Here, what I'm trying to emphasize is the signature of Lading Liani appears on page 2.
Yes.
Signature was obtained by the court. And the following page number 3, Pompuina. Again, we see the signature of Lading Liani, which is completely different from the other one.
So, okay, so you are also challenging this. So where's Lalding Liani now?
Lading Liani is the sibling, sister of the respondent, my lord.
Lalding Liani.
It
Okay, but
was-
she's not a party here.
She's not a party. What I'm trying to say is she was made to put her signature before the court, Lading Liani, and the signature given by her in Pompuina at page 3 is completely different.
But if Lalding
Dini-
Liani is not denying her signature, that will not be an issue.
Apart from that,
she can
my
have
lord.
2-3 signatures.
Yes, my lord. Yes, my lord. Apart from that, she is blind. I wonder if she is able to keep her signature at all before the court as well as before any other place.
But Lalding Liani is not challenging the.
She is not challenging. What I'm trying to say is it is doubtful the NOC obtained by the respondent in obtaining the.
So you want to
airship
challenge? You want to challenge
certificate.
this
Yes,
also?
my lord. That is what I'm trying to say.
Then what happened after that?
Then after that, since we have been occupying the disputed land covered by LSC number 538 of 1973, I was not aware of the
Airship
issuance of
certificate.
airship certificate at all. I came to learn from the person who came and inspected our building, who came to our house inspecting the building, the quality of the said building and so on and so forth, who told me that he was purchasing the
When was
disputed
this?
land.
When was this? When this?
That was
this-
on, well, my application is to be read along with the appeal petition. I have mentioned everything in my,
So you got to know only on. That you tell me on.
facts of the case was narrated and thereafter. I'm just coming back, my lord. So on coming to know I was suspecting my auntie to have obtained the impugned airship certificate from the court. Accordingly, I have inquired from the court, and I came to learn that the airship certificate was issued. So I have applied for a copy of the certified true copy of airship certificate
But
on
your
25.
application is very pleasantly very vague. When did you get to know about?
My lord,
when
I'm
did people
coming
came?
to
No
that.
date is given here. Page 3 is what you have mentioned.
My lord, I'm coming to that.
It is, I would say, pleasantly vague. Nothing, no dates, no proper explanation. You could have got to know about this long time back also.
No, my lord. Soon after coming to know the existence of the impugned airship certificate,
but
I have
when?
applied for that.
But when did this happen? Because you have to explain, isn't it?
Yes, my lord. Yes, my lord. I have. That also I've mentioned somewhere here.
And with the order, you got to know on 25/03/2025. And on 27/03/2025.
Yes, my lord.
There's
I
still
have
the
applied
delay.
for, soon after the suspecting about the issuance of impugned airship certificate, I have inquired from the court and it was there, and I have applied for certified true copy of the impugned airship certificate on 25/3/2025.
Then
And
what
it was
will be the
issued
delay?
on 27/3/2025.
When was the RFA filed?
RFA was filed on 8th day of April 2025, my lord. 8 April 2025.
8/8/2025.
8/4, my lord.
8/4.
8.
So here there's no delay.
There is no delay. Soon after knowing and soon after the issuance of the certificate to copy, I have come to this on board.
Anyways, no other dates is given here.
No date.
So sons have passed away, and you're the daughter of one of the daughters.
Son of the.
You're the daughter of the
I
son.
am the
son.
daughter
Okay.
of the son, my lord.
Okay.
In under the instruction of the respondent, me and my family have been occupying the disputed land. As I have mentioned in my appeal petition, I was instructed to take loan from the bank for reconstructing the dilapidated condition of the building which I am living. And accordingly, we have obtained some loan from the bank, and with that money, we have constructed the building.
Anyways.
In the meantime,
uh,
my lord, some people came to inquire and inspect the building, saying that they are purchasing the land and property from the respondent. Only then we suspected that something fishy going on. So we inquired from the court and came to learn that the impugned heirship certificate was issued to the respondent. Soon after that, we have applied for the certificate copy of the impugned heirship certificate. And without wasting any time, we have filed.
So
the present
what is she doing now, the applicant? If she applied for loan, who's repaying the loan?
Now that
Why are you
was
repaying? Here it's given 70 lakhs.
right. It was apparently the one who purchased the disputed land and building have paid the loan amount to the bank. That was not officially known to us. That was the rumor we have gathered.
But if you're the appellant and you took the loan,
My lord,
then you should be knowing who's repaying the loan.
my lord,
Then letters will be sent for repaying in your name only.
that we will,
You'll have to address that issue.
that is true, my lord, but at the same time, only after recording evidences from the witnesses, we will come to know all these things before the civil court. Here, we are concerned about the issuance of the impugned heirship certificate only.
Anyways, anything else? Huh?
My
Yes.
lord,
Any authorities?
authorities I'm having,
One or two you can give if you want.
my lord, I am having a lot, but
Just give one or two. You don't have to give.
one authority is
Concerning throwing away the merits
My
of
lord,
the
my lord.
case or whatever.
the judgment, the order passed by this honorable court. Para 14.
What does it say?
Paragraph 14. I, with lordship permission, I also find that the merely because in 2012 the wife of the applicant had stood as a guarantor in the bank loan taken by the respondent number 1, wherein the respondent number 1 had mortgaged the LSC number so and so, it cannot be presumed that the applicant knew of the heirship certificate issued in favor of the respondent number 1, unless evidence is showing that the wife of the applicant was informed or made aware of the same. It would not be appropriate to assume that all the connected documents for obtaining the bank loan was scrutinized by the wife of the applicant, and therefore she should know that an heirship certificate in favor of the respondent was obtained by the respondent number 1. It is seen from the documents available that an application was made by the applicant for obtaining the information. Whether the respondent was issued an heirship certificate against the landed property of their deceased mother and the state information officer on 8 October 2018 by letter so and so had informed the applicant that the LSC was no longer in the name of P. Sapungi, but was mutated in the name of respondent number 1, and a copy of the heirship certificate was then given to him. Thus, it can be held from the document available that the applicant got to know of the heirship certificate belatedly on receiving information through RTI Act. The applicant has explained that he had not made any application.
But in your case, when the loan was taken, the grandmother was still alive? Or she was already dead?
No, already died.
Okay.
So the order passed by this Honorable Court is similar to that one. And I have also another order passed by the coordinate bench in this case, although paper publication was done, it was not known to the applicant because the paper publication was done in one paper which was not subscribed by her, and this coordinate bench held that there was no question of knowing the paper publication only because it was published. So, and in this case, the parties are living in the same building. And in my case also, the respondent is living just next to our building. My building and the building of the respondent are next to each other, my lord. So if they want to give us notice, they can give us. They have not. Whereas no objection certificate was obtained from her sibling who is living in Dorpivengthar, my lord, far away from us. Ours is 5 upon, my lord.
Okay.
So, and one more. One more ruling. This Lalfagoma versus Larempui Fanai, my lord. This order was passed by the coordinate bench again. Paranai. The succession certificate issued to the respondent on the basis of the impugned order dated so and so relates to fixed deposit in the name of deceased mother of the parties herein. The applicant and the respondent are siblings, and it is clear that the applicant is a necessary party. However, the respondent failed to make the applicant a party to the case before the learned trial court. Though notice was issued in the newspaper inviting objection from any persons with respect to the application for issuance of a succession certificate.
This is the children.
Yes, my
between
lord, children.
siblings.
they are necessary party. In my case also, since since my family and I have been occupying the disputed land, I am a necessary party. Apart from that, I am the granddaughter of the deceased father, my lord. So since there is no evidence to show that I have
You are the
knowledge,
granddaughter of the
granddaughter of the
deceased.
deceased,
Oh,
LSE
not the
holder, my lord.
deceased father, huh, okay.
Yes, my lord. So with that, I pray your lordship to allow the application for condonation of delay.
Okay. Wait, how old were you when the deceased died? When the heirship certificate was given, how old were you then?
I am, my
Already a
lord,
major or minor?
I am adult,
Was already a major?
my lord.
Okay.
May I please your lordship, this, as per their application, paragraph 4 of their condonation application, their main contention is that they were not made necessary party in the heirship certificate, and no any other grounds, sufficient grounds was made regarding the delay of 1037 days, lordship. So this petition cannot be sustainable, lordship. And I'm come to the point that heirship certificate was issued to the respondent by the senior civil judge Aizol on dated 22/3/2021, lordship. That is in my that is affidavit in opposition. That is annexure 4, page 19, lordship. That is the heirship. And thereafter, the respondent has mutated the land LSCC in her name. That is on dated 5/10/2021. That is annexure 1, page 9, lordship. And thereafter, both the petitioner and respondent have jointly applied for housing loan to the Mizoram Rural Bank, 70 lakhs, for the construction of the buildings therein, lordship. And there, the petitioner herself was a party. Jointly they have present, and loan was sanctioned in respect of the housing loan in favor of the both party, lordship. So that is annexure, that is page 15, annexure 2, lordship. Personal banking advance housing loan scheme, Srimoti Lalwasangi and Zonun Moiren Clay, limited 70 lakhs, lordship. So here she was the party, she was the consented party to the housing loan way before.
Okay, so the land was already mortgaged to the
Yes.
to you in your name.
Yes, yes.
No, but no, the LSC was already mutated in your name.
Yes. And jointly with the petitioner and myself, jointly we apply for housing loan. That is on 18 December 2021. There she was the party, the petitioner was the party, and her name was reflected and her signature was also obtained. Now at the belated stage, how the petitioner can say that it is out of my knowledge that heirship was issued? Because after the issue of heirship, only mutation was made in favor of myself, that is the land. So no explanation was made. It is within her knowledge way back in 2021 already.
So when was it mutated in your name?
Mutation was made 5/10/2021.
Where's that page?
Page, annexure 1, page 9.
Page 8, most probably.
Yeah, page 8 also. And here it is
Your name is Zachi, is it?
Lalwasangi. Father's name
Okay,
is
Lalwa is
Jathinga.
Sangi,
Yeah, Jathinga. Mutation was made in my name after obtaining the heirship certificate. And thereafter only both the petitioner and the respondent has applied housing loan to the Mizoram Rural Bank. An agreement was signed where in every pages the petitioner have also signed. That is way back in 2021 itself that the headship was issued in favor of the respondent.
So the applicant should have questioned how the LSC is in her name of the respondent, isn't it? Anyways, anything else?
And I have two citation, Lordship, regarding this. 2008-17 SCC, Lordship, that is paragraph 12 and 14. 12 and 14. And this
What
is
does it say, para 12?
para 12, paragraph 12 and paragraph 14, Lordship.
What does it say?
That is the Law and Judicial Department as early as on 13/4/2000, that is to say within the period of 15 days from the date of the award of reference court, communicated its decisions to the acquaintance in the decisions of the reference court and communicated the same to all the concerned, including the beneficiary of the acquisition. It is not the case that the executive engineer did not receive the said communication. Having received the said communications, the respondents did not act in the matter and initiated a step for filing of appeal in the appeals if it was really aggrieved by the
So you're saying
decisions
it's
of
incorrect statement because they already knew.
Yes,
isn't it?
yes.
Ah,
And
okay.
we express our reservations as to the manner in which the public authority conduct itself. It is the anxiety of somehow get the relief from the court. In our considered opinion, incorrect statement made in the application seeking condonations of delay itself is sufficient cause to reject application without any further inquiry.
Okay, anything else?
And 14, and
Yes, you want to read another para?
another para 14 is also same, Lordship. Its application made incorrect submission. It had no knowledge of the award passed by the reference court, ought to have refused to exercise its discretions. High Court exercise its discretion on wrong principle. In that view of the matters, we cannot sustain the exercise of discretions in the manner done by the High Court, Lordship. Then another citation. Two 2013-12 SEC, Lordship, 469, paragraph 10. It was stressed that there should not be a pedantic approach, but doctrine that it is to be kept in mind in that the matter has to be dealt with in a rational conscience, pragmatic manners, and the cause of substantial justice deserve to the prefer over the technical considerations. It was also ruled that there is no presumptions that delay is occasional, deliberately, or on account of the culpable negligence, on that the courts are to supposed to legalize justice on technical grounds, as it is the duty of the court to remove injustice. So in this case, Lordship, that there is a negligence on the part of the petitioners, because 2025 itself, when they applied loan, she has the consented party.
2021,
2021.
not 25.
Yeah. So, and no sufficient ground was made in their application except para 4, that main contention is that they were not made necessary party in the heirship certificate. So my prayer is, Lordship, that on the strength of these citations, the application should be rejected.
Okay.
Apply.
May I
Yes.
just give a
Oh,
small submission, my lord?
oh,
So far as the application for condonation of delay is concerned, although I have not specified the date, at para 3 of my application, my lord, I have made, the applicant came to learn that the sole respondent was intending to sell the ancestral property covered by so and so. When some people came to inquire and inspect the building where the applicant and family have been living for the past few years, the applicant became suspicious and inquired from the court on whether the respondent has obtained heirship certificate in respect of LSC number 538 of 1973. Accordingly, certified true copy of the impugned order dated so and so was immediately applied. That means, my lord, the people who came to inspect the land and building for purchase was in the current month, in the said month of March 2025, my lord. So that can be presumed, although I have not specified the date when the people came to inspect the building, my lord. And apart from that, my lord, my submission to your lordship is there is no evidence to show that I have knowledge of the impugned heirship certificate in any case. And I have not made a party. I was not aware of that. And although I've been, my family and I have been living in the said land and building covered by the said LSC, I am supposed to know of the impugned heirship certificate issued by the court. They could have informed me. They could have made me a party. NOC also could have obtained from me. The same was not done. However, since they have surreptitiously done the application, filing the application for heirship certificate, the blind woman, the sibling blind woman who is living at Dorp Viveng Thar, was made to sign a NOC. In fact, my lord, the blind woman could not put any signature at all. She has been blind and they know very well. And maybe because of that, the signature given by her in the two documents are completely different. And apart from that, my lord, there is no question of giving any signature at all for a blind woman. And she was not also produced before the court at all.
okay. Well, what about the submission that you were aware that the LSC was already mutated in the name of the respondent? Because you had also equally applied, signed for.
That I
the
have no
mortgage.
knowledge at all. She suggested that I should take loan from, we should take loan from the bank, and together we put a signature. That's all. If I knew
How
that,
old were you then? That's what, no? Because in the loan agreement, the concerned property is the mortgaged property, isn't it?
my lord,
Which is
was
already in the name of the respondent.
it was mortgaged.
Anyways, so we'll
But-
consider.
My lord, although the said LSC was mortgaged, I didn't realize that it was the LSC of that my grandfather. Of course, I have my signature, but I never knew that the impugned heirship certificate was issued in favor of the respondent at any time. That was my submission, my lord.
Okay. We'll consider, we'll keep it for consideration, okay? Heard Mr. L.H. Lianshima, Learned Counsel, Learned Senior Counsel for the applicant, assisted by Ms. Roth, so-and-so, Learned Counsel. Full stop. Also heard Mr. R.K. Rokum, Learned Counsel for the respondent. Full stop. Having heard both the parties, matter is considered for order. Yes.
Obliged.
Yes, reserved and reserved. Matter is considered and reserved for order.
Item number 8.
Lordship, in this case, it is handled by Mr. Rosang Zwana, the learned counsel. He has some personal difficulties, so if the matter can be taken up on as a fixed item on 21st of October. 21st. 21st or 22nd, anything, my lord.
Okay, make it 22nd.
Yes, my lord.
Lordship,
No,
what about
22nd is
the
the
last week of
Wednesday.
October? Let's do it on 28th of October.
28th of
Yes,
October.
28th.
Okay, October. On the submissions made by the learned counsels for both the parties, list the matter on 28/10.
Yes.
2020.
Your Lordship, in the meantime, if I may be allowed, I'd like to make one prayer regarding IA 113 of 2025. That is a stay application. And
Where?
IA 113 of,
Oh, here in the same thing?
Yes, in the
No,
same
but
case, yes.
condonation has to be disposed. We can't stay anything unless.
Your
we
Lordship,
con-
in that case, in that application, the page number 6 is not correct. So if I may be allowed, kindly allow me to replace that page.
Let's dispose of the condonation first, okay? Because if condonation is not in your favor, you don't have to take any steps for the IA. But supposing it is in your favor, only after that, then you can make a prayer. Anything
Lordship,
else?
my lord, there's some urgency and the leading counsel will not be able to be appearing on the 28th. So if 22nd can be fixed, my lord.
So are you available on the 22nd? No, counsel for the applicant. Both the parties have to be there.
Or we can do it on next month also, November.
One is expressing urgency, the other one is fixing further dates. Well, what happened on the 28th?
My lord, he will not be.
You'll not be there?
Yes,
Then
my
we
lord.
cannot have the matter. So what about
22nd or
24th?
24th, my lord.
24th,
Okay, yes.
okay, on the submission made by the learned counsels for both the parties, since the leading counsel, is it Mr.?
Yes, my lord. Rosang Zoana Ralte.
Rosang Zolarate, for the respondent is not available today. That's the matter on. Then, what did we say? On the 28th, 10th, 2020.
24th, my
Oh,
lord.
24th.
Yes, my lord.
On 24th, 10, 2020.
Thank you, Lordship.
Obliged.
Part 2 hearing, item number 6.
Lordship, if I may make a small request, my lord, with regards to item 4 of today's cost list, my lord, which was earlier fixed for the 21st of October. My lord, my senior will be out of station then, my lord, so if it may be kindly be fixed on the 24th.
But item number 4, who's the counsel for the opposite party? You are there, isn't it? So, okay, so instead of 21st, make it 24th. Just change it to that date. Item number 4.
Yes, my lord. Deeply obliged.
And last, before Ms. Dinari starts, my lords, in part 2, item 7 with 8, connected matters, my lords. My lords, there's been a change in council. In fact, the earlier order we had reflected it. But my lords, we were directed to file our wakalatnama, which my lords, we had failed for some inadvertent reason, my lords. My lords, if we may be given the opportunity to refile, and the matter may be fixed after 4 weeks, my lords. It's right for hearing, my lords.
No, obviously, if it's part 2, it's right
Yes.
for hearing,
Yes.
isn't it?
Yes.
Yeah, we'll pass it on the submission made by the learned. No, but here it is Bilal Ramenga.
Yes,
You're
my lords,
appearing.
change in council, there is there. We were directed.
So what's the order? Let's see if
Yes.
it's already reflected.
Yes. 7.
Then we'll just make it on the prayer made by Mr. Jordan Roming Thanga, Learned Counsel. List the matter after 4 weeks.
My lords, that opportunity, if we can be also
What?
said that.
You have already made here, will be appearing the matter, and it's prayed for
my
4
lords.
weeks' time. So you have prayed, okay, understood the matter after 4 weeks.
Great.
This is item number 7 and 8, part 2. Yes, Ms. Denari, where's the opposite party?
The appellant is not there. However, Your Lordship, this case was referred to Law Adalat and it's settled and agreement is there. Your Lordship, it
Okay,
can
this
be
is item
disposed of.
number? Item number?
6.
6. Let's see, what is the term of the settlement? Okay, so refer the matter to the Lok Adalat. So terms of settlement by the Lok Adalat is here. Okay, then we'll dispose of. Now this is in the Mizo language. It should be again translated, isn't it?
Yes. Appellant is not here. Your Lordship, I just informed Puzawa this morning, and let's dispose on tomorrow, he said.
Oh, since I've already this thing, we'll dispose of.
Just
But the council should be there,
right.
isn't
So
it? So
let
the
him come
council.
tomorrow.
So it's for the whole week. Tomorrow, both of
Yes.
you come. We'll dispose it of. Yes.